Yeah, what's up, kings and queens? We're back again, and as usual, we went to a mirror case to see if we can make some sense out of it. Now, what do you know? Baloyi trying to hijack a witness he discarded a long time ago. Gwabeni was on the witness stand today, getting cross-examined by Advocate Munisi anyway, just to prove that the lies that Zungu told are really lies. Zungu never really met Gwabeni at any stage at the hostel as he mentioned. Now, people are saying Gwabeni will bore them with the amanga. I mean, but I think it's necessary so that we really understand that all of the statement, all of the things that were said on the statement by Zungu and in cross-examination, in evidence in chief, those are lies. And Rata, Rata as always is distracted. You know what I'm thinking? This is what I was posting myself on the comments sections in the live section. What I'm thinking is Rata is not really like Judge Madlanga. Madlanga has got sense, he's got poise, and he's brutally honest. Rata is confused, forgetful, and is always angry, in a rush to judge, Anyway, guys, just listen as Baloyi tried to hijack a witness he discarded. And he's trying to raise the point that this guy could incriminate himself. Yeah, let's look at it this way. If he's testifying point of view of the state as a state witness, as they claim is a section 204 witness, section 206, whatever section it is. Yeah, if he's talking about it, and if he admits, and if that thing is the truth that he was handed the gun by Zungu and what, that will be incriminating himself. But all those things are going to turn out to be lies because that thing never happened. We know that thing never happened. But Baloyi is trying to hijack this witness so that this witness, the way him and Gininda had designated him as. Anyway, check it out.
The statement of Mr. Sfiso Zungu, and that he's the one who told them about the presence of Constable Zungu during the incident and not the other way around. That is the first point. We'll try and find the relevant portion of the record. Secondly, counsel is in possession of a statement made in terms of section 204 by this witness. If the state called this witness, it would have requested that the provisions of section 204 be explained to the witness, but that hasn't happened as yet, my lord. We just wondered, as a matter of procedure, whether if a witness is called by the defense, whether those provisions should also not be explained to the witness.
But does the statement obviously show that it is made in terms of which section?
Section 204.
It's on the...
Yes, it's on.
You must remember, I don't have the statement.
Yes,
I
it's
haven't
on the
seen
statement
it.
itself.
So
Yes.
it says statement in terms of section 204.
Yes.
And then blah, blah, blah.
Yes.
Yeah, okay. Let's hear you, Mr. Munisi.
Asiqale lana-ke umshushisi utshela inkantolo ukuthi-ke ummeli-ke ubekade eqhubeka-ke ekhuluma nofakazi kunamagama-ke awasebenzisayo kufakazi ukuthi-ke uphenyo lwamaphoyisa lwabaholela-ke ku-Constable uZungu umshushisi uthi cha akukho kanjalo lokho kuyistatimende esenziwa kuSifiso Zungu istatimende leso-ke esathi-ke indlela-ke leyo kwatholakala ngayo uConstable Zungu. Okwesibili-ke umshushisi utshela inkantolo ukuthi-ke ummeli unestatimende-ke esenziwa uyena-ke lofakazi uma bekuwukuthi lofakazi ebebizwe umbuso kunesexwayiso ebezosithola-ke ngenxa yestatimende leso asenza ukuyabuza-ke kwinkantolo ukuthi uma ufakazi lona ebizwe abameli ukuthi-ke akufanele yini leso sexwayiso leso asithole.
As it please the court, my lord. The first point relating to where the information came from about the case and involving the arrest of the accused that are before court here, my lord. The sequence is immaterial.
It's what?
From where we're standing, actually from where I am standing. Because
It's immaterial.
that is my submission.
Yeah, no, I just want to hear you clearly.
Yes. Because, and the reason why I'm saying this, my lord, the state investigates a case. Whether they are using a particular sequence or not, I'm not privy to the methodologies that they are using in investigating a case. But all that is before court here is that there is a Constable Zungu who came to this court and gave out the information that we are busy with here. I am busy taking through this witness what Constable Zungu came and testified about being the events that happened on the 26th of October 2014. And the reason why Constable Zungu had to come to court here, come testify, it is because of the work or the investigation that was conducted by the investigating team in this case, who at one point came across Constable Zungu. I think the state is worried about the fact that I used the term stumbled. Let me say stumbled, stroke, came across a Constable Zungu who said, you know what, you probably might want this information that I have. And this is information that I have. He gave them that information. Subsequent to that information, what steps did the investigating team took for my leading of this witness here? That is immaterial. Whether they went to Mr. Zungu, the senior, or they went to somebody else, to me that is immaterial, my lord, because that is their own investigative prerogatives as to whatever that they did. But all that I'm saying is the information that Constable Zungu came to testify about here at court is an information that came about as a result of the fact that the police came across him and he said, I've got this information that can assist you. That is all that I said, my lord. So the sequence on how that information is being obtained, it is neither here nor there. That will be my argument at the end of it all. Now the second point about this witness having made a Section 204 statement, my lord, I don't know what is the state worried about there, whether he should have been warned or what. I'm in the same position as him. He's basically asking this court to come up with an answer to the objection that he's raising. He's basically saying to this court, my lord, this witness has made a Section 204 statement. I don't even know whether he made that statement. I don't even know whether that statement will be relevant in me leading that witness, my lord. But the state is saying to the court, my lord, this witness made a Section 204. And having made that Section 204, I don't know if the defense is allowed to lead him without having warned him of the provisions of Section 204. I've called a witness, my lord. The defense does not investigate on the basis that a witness is Section 204. No. The defense simply calls a witness that they would, which in their mind are saying that this witness will come and assist this court in the presentation of the defense case. Whether that is a Section 204 witness, or whether it is a Section 204 whatever witness. Now the question is, if this was a Section 204 witness, my lord, why did the state not call him? For them to come and complain thereafter that, but no, the defense cannot call this witness because he was our witness in terms of Section 204. Then they should have called him. They decided not to call him. And then you are saying, oh, that which we decided to throw away, I think it will be useful for us. Then we went to the trash place, we cleaned that witness with all the soaps and everything and say, now we are going to make you a human being. Come and testify, come and tell this court, what is it that you know about this incident? Then the state stands up and say, No, but we should have warned him. No, the defense does not call a witness on the basis that that witness uses Section 204. That's a prerogative of the state, my lord. But if they decide not to use him and discard him, we'll definitely pick him up from the trash place and come and bring him here to court to come and tell this court what is it that he knows about this case. So I find no reason for the state.
Yeah, but you guys are not addressing me in terms of the law. It's okay to talk and talk and talk and talk.
That is the state that must do that, my lord.
Mr. Baloyi, are you saying this witness is impeachable?
Well,
That's the legal language you must
yeah.
be addressing me on, not...
Yes, my lord, we're raising issues of procedure. There's Section 203 and Section 204, and that refers to the rights of a witness. And I think every witness needs to be apprised of such rights. It's not dependent on the witness. It's a question of procedure. Counsel has been asking a witness, for instance, whether Constable Zungu gave him a firearm, to keep it for him. I think this witness needs to know what his rights are as far as incriminating questions are concerned. And secondly, as we mentioned, my lord, that this witness doesn't just come as an ordinary witness. There's a certain status that is accorded to him, and that needs to come on record, my lord, that what type of witness he is. But regarding the first point that we raised, my lord, we differ from Advocate Nisi with the greatest of respect. It's crucial. If he's approaching the evidence from a wrong perspective, then that goes to the heart of this witness evidence. If the evidence of Brigadier Gininda is, as we say, that his statement was obtained first, and that they learned from his statement of the involvement, of the presence of Constable Zungu, that's crucial. It goes to the heart of this witness evidence. It goes to his credibility. It's been saying that Constable Zungu is lying all the way, but if his evidence is approached from the correct perspective, as testified to on record, that might change the approach to the witness. That's all that we're saying, my lord. And Advocate Nisi says the sequence is not crucial. It is crucial because it goes to the credibility, it goes to the way that his evidence should be approached, and. My colleague has just referred me to the evidence of Brigadier Gininda on the 1st of November 2024, page 25, line 2 to 9, where he says, "There are statements that are obtained. I'm just not sure if those witnesses have testified, but during the course of the investigation, before Constable Zungu's statement was obtained, there were statements obtained which linked all the accused in this offense collectively from accused 1 to 5. And those statements are in the docket. This part doesn't specifically refer to Mr. Sfiso Zungu, but we're still looking for that specific portion that wherein Brigadier Gininda testified that it is as a result of the information that was furnished by Gwabeni, as is commonly known, that he then approached Constable Zungu.